Hello children, I welcome you to another session of the Indian Judiciary. So, without any delay, let's get started. The Indian Judiciary. In the previous video, I discussed about the functions and powers of the Supreme Court. Today, we will discuss some other functions of the Supreme Court. Writ jurisdiction. The writ jurisdiction clearly states that the Supreme Court can issue writs to get our fundamental rights reinforced or implemented. If any of our fundamental right is violated, we can approach the Supreme Court. And then the Supreme Court, if satisfied that our fundamental right is violated, can issue writs to order a particular organization, person, or institution reinforce our fundamental right, to restore our fundamental right. And they are held guilty by the Supreme Court for violating the fundamental right, and writs are issued to them ordering them to reinforce, restore the fundamental rights. So this is the writ jurisdiction, and hence Supreme Court ensures that our fundamental rights are guarded and taken care of. So, the Supreme Court is the guardian of the fundamental rights of the citizens. Then, let's talk about advisory jurisdiction. The President may seek advice from the Supreme Court on matters related to laws before formulating plans and laws. Before formulating policies, he may seek advice from the Supreme Court so as to make a rational decision, to make decision in the light of knowledge and advice received from the Supreme Court. However, remember, advice sought from the Supreme Court is not binding on the President. She may seek advice from the Supreme Court, but the President can make independent decisions. The piece of advice given by the Supreme Court is not at all binding on the President. He might seek advice from the Supreme Court, but then it is not binding on him or her. Then, Court of Records. Court of Records. The Supreme Court acts as the Court of Records, which means all the verdicts given by the distinguished judges of the Supreme Court are preserved in the written form, and hence Supreme Court maintains record of all the decisions in written form. These records help the novice, the new lawyers, to make better judgments. So, Supreme Court acts as a court of record. Then, how is the Chief Justice of the High Court of a state appointed? See, we have discussed how the Chief Justice of the Supreme Court, New Delhi, appointed. Now let's discuss How is the Chief Justice of the High Court of a state appointed? She is appointed by the President of India, but the President of India consults the Chief Justice of the Supreme Court and the governor of that particular state. So, I repeat myself. The question is, how is the Chief Justice of the High Court of a state appointed? She is appointed by the President of India after consulting the Chief Justice of the Supreme Court and the governor of that particular state. So, the Chief Justice of the High Court of a state is appointed by the President of India after consulting the Chief Justice of the Supreme Court and the governor of that particular state. And governor of the state is also its nominal head. The way the president is the nominal head of the country, the governor of a particular state, say UP, the governor of UP is the nominal head of Uttar Pradesh, and the chief minister is the real head of a particular state. So, if I talk of our country, the real head is the Prime Minister and the nominal head is the President. And if I talk of a particular state in India, then the real head is the Chief Minister and the nominal head is the Governor. How are the other judges of the High Court appointed? For this, the President may consult the Chief Justice of that concerned state, and the Chief Justice of that concerned state has been appointed by the President after consulting the Chief Justice of Supreme Court and the governor of that particular state. So, to choose the other judges of the High Court, the President may also consult the Chief Justice of that particular state. Then, now we will study about the qualifications needed for the High Court judge. To become the judge of a High Court, the person should be a citizen of India, must hold at least 10 years experience as an advocate in the state, and must be a distinguished jurist or a well-known writer in the field of law. I repeat myself. To become the judge of the High Court, an individual should be a citizen of India, must have 10 years experience as an advocate, of at least 5 years in the state, and she must be a well-known writer in the field of law or a distinguished jurist. So, to qualify for the High Court judge, an individual should be a citizen of India, must have at least 10 years experience as an advocate in the state, and must be well-known writer in the field of law or a distinguished jurist. With this, I wind up the session for the day and request each of you to revise well and take very good care of yourselves. Thank you and have a great day.